Hello, good afternoon, everyone,
Good
and
afternoon.
good afternoon, Vasan sir.
Good
Uh,
afternoon.
and a very warm welcome, everyone, to Logical Talk number 37. In fact, with this session, I think we have closed our loop of 3 years. So we did our first webinar uh, along with our friend Anurag in May 2023, right? And this is 37th. With this, we complete 3 full years of cycle when we have done webinars every month on different topics with different speakers every month without a fail. And one thing I must tell you that when we started, we were not very sure that with this initiative we will be able to sustain because you know there was a time when, specifically during the COVID, when everybody was doing webinars, there were so many webinars happening, and it was somewhere around right after a couple of years after COVID. We were starting it, but people were getting fed up of it, of webinars. But I think thanks to all of you, we have been successfully able to sustain this initiative and bring every time a new topic. Something which is current, which is impacting the corporates, the businesses, and something uh, which all of you wants to know. And have been very fortunate, I would say that way, that we have been getting very efficient, effective speakers also in all the webinars. Uh, and those discussions have really uh, initiated interest. And that's where I would say, even today, when we are doing a 37th webinar today also, the number of registrations are almost 400 plus registrations for this webinar as well. So I would say thanks to all of you who have kept this interest alive and kept us motivated also, that we keep doing these webinars. And I also have with me my colleague Trishul, who leads this entire initiative. Trishul is one of the founding member in Lawrbit, and been running this initiative, which we call as Community Connect Initiative, very successfully with 37 webinars. And when we are doing this webinar, they're already thinking of the webinar topic for the 40th webinar, and trying to talk to speakers for the next three webinars also. So along with this, we have articles, procedures, and I'm sure if you're listening to our webinars, you're also going to our website, surfing our articles, procedures, and there are plenty of them. I would always welcome all of you to give your feedbacks on those articles, webinars, and show interest if you want to collaborate with us in any of those articles, procedures, compliance calendars, case studies, webinars. We are more than happy to have you on board in this initiative. It's an initiative where we are just trying to bring some more value, more knowledge to the fraternity. That's it. Be a part of it. Let's grow this community together, bigger. Customary slide, coming back on the customary slide. Again, before I speak, I'm sure you know what I'm going to speak. So a uh, quick introduction about Lawrbit. We are India's leading regulatory technology company. I think with a distinction that we are offering not just a India-based regulatory compliance solution, but also global with compliance software with global coverage. Today, we have done projects in 70 plus countries, and as we speak right now, we are serving more than 650 plus entities, 4,000 plus locations, 15,000 plus users. And as we speak right now, we are a team of 118 legal and technology professionals who are working behind the scenes to get this solution software for you. Beyond regulatory compliance, we offer legal matter management, which is litigation management and internal financial control, to regulatory compliance, audits, health checks, and other services as well. With this quick introduction, let me jump onto the topic of the day, which is a very interesting topic, and I know you're all excited to hear about this. So I have with me Mr. Vasant Kumar, and I just want to, say one thing about Vasant sir. That there are at times speakers you want to get on board, and there are at times speakers who your audience wants to get on board. So we have been getting a lot from clients and audiences that Vasant sir should be taking this topic. And once earlier also we were trying to get Vasan sir, I think more than a year ago. But unfortunately on that day there was an emergency in his family and he had to drop out on the very last minute. Vasan sir, uh, I don't think you need any introduction, but I'll still try and do a bit of justice or whatever is written. I'll try to just talk about it. Vasan sir is is a CEO, a retired CEO and labor commissioner from the government of Karnataka. He comes with more than 32 years of expertise in labor laws, industrial relation. Post-retirement, he is also engaging very deeply with the corporates, with the businesses, and he is providing consultations to clients like Shai Export, Hindalco, Tata Marco Polo, Orkla India Limited, and Yokogawa, and many other. His experience is in both government side, and from the position which he held, people are and from the industry side as well. Plus, he's somebody who is very well known in the fraternity, and people are excited to listen to him. And there are more than 150 webinars, workshops on labor laws which he has conducted so far. So, Vasant sir, uh, thank you so much for your time and being here with us today. We are excited to hear you. And I also have Divya. Divya Chauhan. She is a Pune-based lawyer. And Divya, I would want you to take a minute because there is one thing in your in your profile which really interests me beyond whatever more talk that what experience you have. I want you to spend a minute to talk about Spurti Foundation and your Heart to Impact Foundation. What are this? What are you trying to do in these organizations? Somebody with a very limited expert interaction I had with Divya, but what I've heard from my colleagues and some of my earlier co-panelists, Anurag being one of them, uh, talked very high about Divya. And somebody who's very deeper into her subject, with somebody with a heart, uh, and I would say a passion to talk on this subject. So, Divya, welcome and thank you so much for being here today.
Thank
Can
you
you
for
take
inviting.
can you take a minute to talk about Spurti Foundation and Heart to Impact?
Sure. So thank you, first of all, for inviting me for this very important discussion. About me, yes, I'm a lawyer. I'm into litigation for the past 16 years. But at the core heart, I'm truly passionate about causes which really impact the society, be it women, be it children, or be it even environment. So, because I'm so passionate about these three topics, actually drove me to start the topic of create sensitization on prevention of sexual harassment as actually a social service, which of course then became a professional service eventually. But because of that, I have been constantly working in this space. Also, we have been working with children to create awareness on POXO, which is child abuse, and now, of course, handling several cases for the victims where we have got justice for them. So that is through our organization we do these sessions as well. The second thing from Spurti, which is a 25-year-old organization, we give skill development to women who can keep their handcrafted products on the platform which we provide to them. So it's in collaboration with the government, and it has been recognized as one of the best practices for poverty alleviation. So that is one of the flagship projects of Spurti Foundation called Smile. Under Spurti Foundation, like I said, we do work on women empowerment. We also work with schools to create awareness on climate change, because I think environment and climate change is something that we are affected on an everyday basis, with the heat which is going on, with erratic rainfall. So women, child, and environment is something which we work on at the grassroots here in Pune and here in Maharashtra. And because I'm so passionate about social work, and because I am also connected to several organizations, so several companies, I actually help them visualize what change they want to bring about in the society, and help them ideate and create that social impact for them. And that is through Heart to Impact, which we have just recently started to help companies visualize their calling, and ensure that they are compliant with the S in the ESG. So that is what we are now offering through Heart to Impact.
Thank you, Divya. So, let's get started with the discussion.
Hi, everyone. So, also today, Mr. Jayant has given my introduction already, but I'm also a presiding officer of POSH committee at Lawrbit. So that's why I'm here to start the session. And so we are starting. So we all know why we are having this session. So last month only, we had this very major case, POSH case, TCS Nasik case, if I want to quote, in April. So that's why we have got a very simple topic, but I'll make sure that this is not just a compliance awareness session for you. We are here to talk about the real workplace dynamics, safety, and accountability. And by the time I'll make sure you leave this room, you won't just have the law, know the law, but you will understand how it actually lives and breathes in our day-to-day work. Right. So the agenda is we'll talk about the applicability of how the sectorial, geographical, and the general applicability of the law is, the core definitions, which constitutes where the workplace, has an end in a hybrid world, what actually constitutes sexual harassment, and we will strip away the gray areas. About the mechanism of the POSH, we'll talk about the composition, tenure, and the employer obligation, and how to ensure a safe ecosystem. We'll talk about the IC inquiry timelines and the consequences. We'll map out the strict, non-negotiable legal timelines from the moment the complaint is filed. And beyond the text, if we want to make our audience aware about it, is the myths, the real-time key pronouncements, the real-world court judgments that shape how the law is interpreted today. So in short, this is the short agenda. So I want to start the session by all of you looking at this phrase on the screen, but I meant it as a compliment. So we are laying this phrase to rest today, and just to understand that in the modern workplace, specifically under POSH compliance, intent has no importance. And that is why the regulatory authorities, the courts, the external auditors, they do not care what your, what you have thought that you were doing. They are not the mind readers. They are looking at one thing: the concrete compliance frameworks your organization actually has on paper and what they are practicing. Because today process is everything, it's a king. So if I want to talk about the applicability of the POSH, there is a rule of 10, which is a threshold of compliance, a very general applicability. The operational requirement of the act is based on the headcount of an establishment, where it says that employees with, establishments with 10 or more employees, the employer has to constitute a IC at each office, at each branch, and at every administrative unit that has 10 or more employees. So if a company has a corporate office in Mumbai with 50 employees, or a warehouse in Pune, let's say with 12 employees, both locations needs to have IC set up. And where the establishments have fewer than 10 employees, they are exempt from setting the internal committee. And if the complaint arises, let's say from a small businesses or startup or an unorganized sector, The aggrieved women registers her complaint with the local committee, which is a district level committee set up by the government. If I want to talk about the extraterritorial jurisdiction, means working outside. So the common question here arises, does the POSH apply if Indian employee is harassed while on a international assignment? So yes, if an employee is on international business trip, attending global conference or working at an overseas client site on behalf of Indian employer, the Indian organization IC still holds the jurisdiction, because the definition of workplace includes any location visited arising out of or during the course of employment. So the geographical borders do not absolve an Indian company of its duty to protect its employees. Here also, the applicability of POSH is now applicable in J&K also in post 2019, while the abrogation of Article 370. The sectorial applicability is where POSH applies to, as we all know, public, private, government, non-government, organized and organized sector, right? And what POSH doesn't cover, it doesn't cover men, transgender, or any non-binary employees. Also, you might have a question that I have a, no women payroll, although I haven't seen such cases. But in case you have a question, we have the applicability for that also, that even if you have 100% male company with 10 plus employees, they need to comply. The POSH protects any women stepping in your workplace ecosystem. So it could be any female client who's visiting you, any vendor, any visitor also, any auditor, job interviews, internees, if they come for the interview, any delivery executives. So even companies with 100% male employees, they also need to be adhered by this POSH law. Right. So Divya and Mr. Vasant, if you have anything else to add to it, after this, I hand it over to you for taking up the next slides.
This dwelling house, a household also is a workplace.
Yes, that's an unorganized sector, sir. So that's a dwelling house, which we'll cover later. Yeah.
So Divya, before you jump in, I just want to add one thing, and for our audience also. So far, whatever acts we've spoken, I think we have spoken about RBI to SEBI to income tax to GST to, and I think we have covered a plethora of laws. I think only one previous on modern slavery and this one. I won't say modern slavery also. I think this is possibly the only law where it is not everything black and white. There is a lot of gray also there, because of how we understand, how we interpret, how we feel. So understanding those aspects, and specifically in a dynamic environment today, where I would say there is in a workplace, there is somebody who's a 50, 60-year-old, 50-year-old, and somebody who's just 22-year-old, 23-year-old also. Somebody who's coming from a metro town and somebody who's coming from a remote village also. The way we perceive things and way we understand things, understanding for somebody, it may be a normal thing. For somebody, it may not be. Here, more than understanding law, understanding intent is very important. And I would, I would request to keep the chat box on today. If you have any queries, any thoughts, any experiences, any case laws you want to share with everyone, let's keep sharing, because after today, if I can say, we're proud to say that in Lawrbit, we are more than 50% women. Colleagues we have, despite having very rigorous, very stringent POSH policies implemented, still there is a new learning every time when you hear the trainers who we invite from the external bodies. There are something new to learn. So I think this is a learning session for all of us, and I'm sure by the end of it, the discussion from all of you, from our experiences, from your experiences, let's try and learn from that perspective. Let's keep the chat box open. I will be concentrating more on the chat box, and Divya, Vasant sir, I'll keep interrupting you in between when I have any interesting questions and perspectives from the audience.
Sure. I know this topic as such is not black and white at all. It is very, it's got so many different aspects to it. And I think it is very difficult sometimes to assess what can amount to sexual harassment and what may not amount to sexual harassment. Because for every person, how they perceive it, the intent, and how it impacts them is also very, very important. But of course, the law has defined sexual harassment. We all know that the law has defined sexual harassment. We know that there is section 2N, which gives the definition, be it physical contact, advances, demand for requests for sexual favors, sexually colored remarks showing pornography. I think, we need not even talk about these aspects because that is very, very clear. What is interesting, if I may say, under this law is any other unwelcome acts which are directly also or by implied in nature, which are verbal and non-verbal in sexual nature. So, what is important here is the word unwelcome. Unwelcome for whom? Unwelcome for the person who is actually facing such incidents of feels that uh, these actions by the opposite person is not appropriate. So that will amount to unwelcome, and it is verbal as well as non-verbal of sexual nature. So there are so many aspects to it. Non-verbal may even sending a message or even looking at a person in a particular fashion will also be covered under the act. Also sometimes following that person, which of course amounts to stalking, but constantly following, which makes the person feel uncomfortable, those all are also included within the definition. In fact, the definition does not just stop at section 2N. It goes even further, which defines it under section 3.2, promise of preferential treatment. These are the typical, in the normal parlance, we can say the casting couch situations, which we heard a lot during the Me Too movement. But in the legal parlance, we call it as the quid pro quo. That is something in instead of some other favor. So promise of preferential treatment, that I will give you a promotion, or I will give you some favors if in case you comply to whatever I am demanding. Threat of detrimental treatment, that I will remove you from the job, or treating the other person in such a way, not including that person within the workplace scenario as well. Threat about employment status, interference with work, humiliating treatment. So all these are given within the law. But what is important here is also not only quid pro quo situations, but interference with the work. Or humiliating treatment, creating an offensive and a hostile work environment. Many a times, these actions or these instances of sexual harassment are not direct. Some which are direct, of course, it is apparent and it is very easy to understand or identify this as sexual harassment. But there are many instances which are not exactly, the other person may not perceive it as sexual harassment, but it may be sexual harassment. For example, there was a in one organization, there was somebody who was constantly putting their hand over the shoulder of the woman employee, and that made that person extremely uncomfortable every day. And because he was of such a senior person, he was of course not only in age but also in position, and therefore this was unwelcome towards her. And with his intention was not to make that person feel uncomfortable, but for her it was unwelcome, and for her it was sexual harassment because she felt uncomfortable. It was the intent with which also he put his hand across that was not comfortable. So it really, maybe a hug is also okay for some people. With, if colleagues become your friends, sometimes language, sometimes interpersonal relationships, behaviors is permissible for some, but it may not be permissible for the other. So it is very important to understand what is the culture of the organization, what is the code of conduct of the organization, and all these instances, and being very clear about the definition that even the unwelcome, if it is unwelcome for the person, you need to stop. You need to understand where that your limit is of or the line of professionalism is as well, because in no way the other person should feel um, intimidated, or should be humiliated, or there should be any hostile work environment which will be created. What is interesting to note is that sexual harassment, the definition which is given under the law, it is the same definition which has been taken from the Vishakha guidelines, which the Supreme Court had passed way back in 1997. So it's very important to note that it is the similar definition which has been taken. Further, if you see, of course, sexual harassment is defined under the 2013 law of sexual harassment of women at workplace, but it is also defined under the BNS Act, which is the criminal laws, which of course we will talk about, but the definition is the same when we speak about sexual harassment.
Divya, if I may say that the handshake, the handshake which is given by the male superior or a male colleague to a female one, see, it lingers. The handshake lingers for a period which is not required, I tell you, and it is pressed, which makes the female counterpart very uncomfortable, I tell you. A very subtle way of what you call that, touching the hand and then holding it for a longer period than what is required, I tell you. This also happens quite a lot, I'm telling. And then fingering takes place inside, I'm telling. This is something which has to be abhorred, I tell you. And another thing, if I may add here, see, notwithstanding all this robust framework to tackle the sexual harassment problems, the central person for whose benefit this act is enacted, that is the woman, I find during for the practical experience, there is a lot of hesitancy amongst the women to come forward and blow the whistle. A lot of hesitancy. Very rarely they come forward. A lot of hesitancy they come forward, where they feel uncomfortable to appear and then face questions and all. This has to be overcome by the employers, especially labor-intensive companies, especially female labor-intensive companies like garments, etc., which I have seen, I tell you. So 2,000, 3,000 employees working in a unit, I tell you, hardly one or two people come in a year, hardly one or two. There's a lot of hesitancy factor, I tell you. Something needs to be done about this hesitancy to overcome this hesitancy.
Absolutely right, sir. You know what you said, even the way a person has also given a handshake, if it goes for too long, it may be unwelcome also towards a particular person. And if you're talking about today's day and age, when we talk about everybody is on the digital world, so even we have to be so careful to understand that what are our behaviors or code of conduct even on the digital platform, because many a times we know that workplace, we've already dealt with it, that it's not only our office, it is also, it extends, there is a notional extension of workplace which goes beyond workplace as well, a place which you're visiting, transportation, and sometimes the lines also get blurred about workplace as well, because not necessarily you met somebody at work and then that relationship, what you have with that person continues sometimes even after work hours, or um, after your once you leave office as well, but the place you've met is at workplace. So sometimes even digital workspaces, how we are conducting ourselves is extremely
Yes.
important. Many a times we've seen that people send messages, especially after work hours, to their female colleagues. Sometimes somebody in their team who is very junior or who has newly joined the organization, and there are chats which continuously go on, and that can get uncomfortable as well. That can be unwelcome as well. Emojis can get uncomfortable as well. They can be unwelcome as well. The hug emoji, the heart emoji. Uh, if you're not my friend, or if I don't have that comfort level with you, it's going to be unwelcome if I'm going to receive. So the definition of sexual harassment needs to be seen in a wide manner, especially that part of any other verbal or non-verbal conduct of sexual nature. So even those instances where somebody is send me your video, send me your, or sending some jokes on the social media platforms, or even constantly stalking on social media also can amount to sexual harassment. Of course, a lot can be spoken about this definition, but if there are any questions coming in, we'll be happy to discuss those. But so I think it's very important to understand that these concepts, one is sexual harassment, and the other three important concepts under this law. The second is aggrieved women, because sexual harassment of women at workplace. So clearly this law is for women, where women can come forward and complain. And many a times there are so many people who say that why not men, because men also face instances of sexual harassment, which is a true fact, which we cannot really deny in today's day and age, and especially in urban areas. Um, but the law, as we all know, that the Vishakha guidelines were taken as it is, and then they were then translated into a law of 2013, and therefore it was women. And there have been several studies which show that women face more instances of sexual harassment vis-a-vis the male counterpart, and of course therefore women. So but as of for now, it's only women who can file complaints under this law. But if there are men who can, if there are organizations who are of course progressive in nature, they also have policies which are gender neutral, which may treat sexual harassment as a misconduct for men as well, and then for any other gender apart from women, which can be also dealt with by the company policy. But here it's only the aggrieved woman who can file a complaint. And the definition of aggrieved woman is quite broad, because the company policy will only be applicable to employees. But under this law, it's not only the employees who can come forward and file a complaint, but it can also be consultants, it can also be interns, it can also be visitors, it can also be clients who can come under this law and file a complaint. There was a very interesting way to know that there was a hospital where there was a lady was visiting her relative at who was a patient there, and she in the lift there was a ward boy who inappropriately touched her. Now she went and she filed a complaint with the concerned internal committee. The question arose that is this complaint can she actually file a complaint under this law? Yes, even if she is a visitor, she can still file a complaint, because it is the duty of the employer to ensure that their workplace is safe. And therefore under this law she can also be an aggrieved woman and file a complaint with the IC of that workplace. Further, even if the harassment, the law has gone to address all kinds of women, even women who are in a dwelling house. If they face, who are working, the house help, etc., they face any instance of sexual harassment, even they can go and file a complaint. Of course, there is a different forum for that. It is called the local complaints committee, or the local committee which the state government forms. But that is the definition, how broad it is. So it is not only women who are full time on duty, but like I said, it is part time, contract laborers also which are there. Even for example, housekeeping staff, sometimes the organization also appoints. Even they are supposed to be safe. So there's a broad definition. Going further, workplace. Like we said, there is a notional extension of workplace. So if any incident of sexual harassment happens at office, of course we need to address it. But like I said, notional extension of workplace, which also includes other spaces. For example, if somebody has gone for a conference to another city, that will also be a workplace. Uh, so so it's not really defined, and there are many grays there as well. Digital workspaces is something which is also included. And very important to know is work from home setups is also a workplace. Virtual meeting platforms, WhatsApp groups, because many a times we feel that WhatsApp hai, so it's a very informal platform, but no, even that is a workplace. So hotels, team dinners, parties, conferences, team outings, all these are workplace. So because many a times these incidents happen not in office, they happen at these at people when they are not in a professional setup, when they are more informal, in more informal setup. So parties, even conferences, um, even team outings. So work, many of instances of sexual harassment happen at such places, but it is very important to take cognizance of these incidents as well. um, Moving forward, when we speak
So,
about
Divya, before you move forward, just a couple of questions I have for you. Uh, you mentioned that companies can have a internal policy covering men and other genders also. Also, uh, what in your experience do the organizations do? Uh, do they really have policies? For for men. Second, if some such cases are comes up, what kind of a recourse do they have? Because this is POSH is an act, and your committee which you form is governed by the law. Any decisions of the committee can be enforced. But if you have a policy for men, does it have any legal standing? Does this policy have any kind of take any can an organization take any decision or any action basis that policy?
So basically, every policy of which any company has treats sexual harassment. There is supposed to be a zero tolerance towards sexual harassment, and it is supposed to treat sexual harassment as a misconduct. That goes without saying. And secondly, in order to prohibit any kind of sexual harassment, so the objective of the law is prevention, prohibition, and redressal. So the policy plays is one of the aspects in prohibition of sexual harassment. So it is always a best practice to have a policy in place so that you prohibit sexual harassment. Prevention will be having awareness sessions, redressal is having your IC, and prohibition is having a policy in place. And that is something which is very important. Second, of course, the law is the act will be more important in nature because it is the law which is there. But even the company policy is equally important within the organization to maintain that kind of discipline within the organization. So any kind of misconduct, the disciplinary authority uh, has to take action accordingly, especially if there are standing orders in place, etc. So it depends on what kind of organization or what kind of company you also are in, and accordingly they have to take action through the disciplinary committee. But of course there are two different things. The people who, other than women, who if they want to file a complaint, they have to file a complaint, and the disciplinary authority, because it will be a misconduct, the disciplinary authority will look into these matters. But whereas if a woman is filing a complaint, then of course it is before the internal committee only. And of course within there are many organizations, many organizations want to just stick by the law, but organizations also ensure that their company policies have this aspect of having zero tolerance of sexual harassment and treating it as a misconduct. So I think it is people have started revising their policies to ensure that they include such prohibitory measures within their policies as well.
One next question. When you talk when we are talking about workplace, typically, and a very important point you said, the definition of workplace. Many times we don't understand. We think that it's only the office, the workplace. So wherever, and if you're on a travel, if you are with your colleagues, even if it's unofficial, is it also should can that also be considered as a workplace? Let's say I'm or is it only if it is official? So, for example, I'm going out with my colleagues. Uh, not on the official duty, not on the official party, okay, uh, but with my colleagues.
Yes.
So is it workplace? Can that
So,
be defined in a workplace?
so of course, if it is an official party, if it is official outing, it will be a workplace. But many a times your colleagues become your friends, and then you have informal outings as well. You know, with your friends who are colleagues. But you know what? Of course, that will not be a workplace as such. But many a times, these instances come back to your workplace. For example, if some incident has happened when two individuals have gone with consent outside, and some incident happens, of course that is their personal time, uh, where when this incident has happened. But when they come back to work, then again there is going to be a lot of discomfort within their interaction. So then that is something which people may come and may speak about to the IC as well. So while many a times incidents happen not as at workplace per se, but it may be connected to your workplace. And if it is connected to your workplace, especially when there is a subordinate, there is a hierarchy in place. There's a team lead and there is a person who's working in that team, and then something happens with the girl who is in the team of that team leader. Then of course there is a power position of power, and that has to be taken because there is a misuse of power. If there are two colleagues working in the same team, but they are working on a project, and if they are not going to be comfortable with each other, so then of course it is important to address these kind of situation. But if there are two people, one is in Pune and the other person is in Bangalore locality, and there is just no um, there is just no communication whatsoever for work, also for work purposes, nothing at all. So it depends from case to case. Like we said, nothing is black and white, everything is gray. So we have to really ascertain at that time whether or not it is work from home, whether or not it is arising, or it is affecting the employment. So there are many things which one will have to really consider while addressing it. And if it is something which it is affecting each other, and if it is affecting the workplace ethics as well, then it is important to address these situations.
I hope you understood, where I was coming from, because, with the current generation, and I was said, where I was talking about, somebody who was 50 and somebody who was 25, there is a very different understanding about the morals and and the conduct, some language, some actions, as you said, and as I was saying, holding a hand for a little extra, longer also could be, could make somebody uncomfortable. But there is a generation who feel today, who has a very different kind of a slang, and they're also at my workplace today, right? And that's a common language for them. And the definition of moving out, and that's where I think a lot of cases we are also seeing in the workplaces. Today we are good friends, we are going out, everything is very good, and suddenly there's a POSH complaint. There's a lot happened in between while being friends, and then there's a POSH complaint. I want you to maybe if not right now in the next in the next slide, but I want you to talk about this. What are the different kind of scenarios you're encountering, and how your organizations are today dealing with those scenarios also?
I think this issue can be discussed maybe at the time of handling inquiries and handling complaints, how to do it, because at that time how to address these situations is something which uh, plays a very important. It's very important to understand at the time of addressing these situations, which I think which sir is definitely going to speak about in the next slide. So we can certainly talk about such situations as well. But as you rightly said, there are two generations working together. There are people from different backgrounds who come together and work as well. There are even from different cities. Some are from the urban areas, some come from villages. So there is a different mix of backgrounds where people come from, the baggage which they carry as well. And especially now with so many, with mental health also playing an important role, there are so many aspects to situations. And I think 1 hour also will not be sufficient to talk about these different kind of situations, but we can certainly discuss at the time of inquiries. But I think moving forward, we need to really understand who, against whom a complaint can be made. While a complaint can be made by a woman, but the respondent, it's not mentioned that it's only a male against a male. It can be any person against whom the aggrieved woman has filed a complaint. So it is a gender neutral uh, definition of a respondent. And again, it is not only that that person needs to be employed with your company. It can also be a person having some kind of a work relationship. It can be a co-worker, it can be a manager, it can also be a third party vendor, or a client or a visitor. Many a times your employee, your women employee is going and meeting another client, and maybe has faced certain instances of sexual harassment. It can happen also with a person at a conference which we have gone, where several companies have come together, and maybe a person who she has met from another company, and even that person would have who she has felt uncomfortable with or unwelcome. Even that person can be a respondent. So here you need to understand that there has to be a work relationship between the aggrieved woman and the respondent. So that is something which is important to know and to understand, because many a times we have this, that it will be only the person who you're working with within the organization. But again, even the respondent has a broader definition. So it's not necessary, there has to be a work relationship. And then moving on to the next slide, we really need to understand who are the people who actually address these kind of situations when sexual harassment does happen. So we come to that part of redressal. So when we say redressal, there is an internal committee which has to be constituted by any company with more than 10 employees. So here by 10 employees, it's not necessarily only that only if you have a female, then you have to have this committee. Even if you have an all male company, especially in the manufacturing setup, when we see in factories, which we see that there are more, there may be only a one woman, or maybe all men as well. But even here, you need to have an internal committee, for the simple reason that an aggrieved woman, like we already discussed in the definition, it's not necessarily that she's appointed or she's an employee of the company. She can also be somebody who's visiting that place. So you have to have a committee, which is a mandate, not only by the law, but also now by the by different state governments in various notifications. Secondly, is also by the Shebox portal, which is by the government of India. So, and the committee mandate is it's given under the law. It has to be one presiding officer who has to be a woman. There have to be minimum 2 employees within the organization, and one external member who is not a part of that company, who is either a lawyer, or is from an NGO, or has experience of social work for at least minimum 5 years. So these are the members of the committee. Now, this committee has to be in every workplace. For example, if you, like, I think you've already dealt with this. So if you have a company here as well as a factory set up somewhere in, suppose in UP, you will have to have a committee there as well. It can be the same committee, but it's always advisable that you have members representing from that workplace, because otherwise you will not know what is happening at the ground level. So it's important to have constitute a committee properly at every workplace. So, and the tenure will not be more than 3 years. 50% have to be women. So one needs to understand that you have to prevent, you have to prohibit, and you have to give a redressal mechanism. So that is very, very important. And how does the internal committee work? I think, we will be seeing in the next few slides.
Also, in relation to this slide only, Divya, there is a question in the Q&A part that can a male senior employee become a chairman of IC? So
No,
if
a
you
male
can.
employee cannot be a presiding officer. It has to be a senior woman employee. Again, if you don't have a senior woman employee, and if you have a woman director, clearly the women director cannot become a part of this committee because that director has a position of an employer, whereas here it is senior women employee. So you have to hire then a woman employee at a senior position.
Right.
So
And the other two employees which we are saying, could be are the part of IC. So it can be male or female, right?
yes, it can
Preferably the
be
individuals who are committed
exactly.
to the cause of women or have
Yes.
experience, right?
Yes, yes, they can be male as well. In fact, it is advisable to have men within the committee because there is a balanced approach towards any issue which comes up. And many a times, even if men are uncomfortable talking to the committee when they're all women and they want to talk about certain aspects which they're not able to open up to women, then at least they can talk to that male member which is there in the committee. So it's important to have a balanced committee, but at the same time, it must be remembered that 50% have to be women. Even the external member can be a male member.
Okay.
Only thing what needs to be remembered that 50% needs to be a women. There's a reservation here.
Right, right. Thank you.
Yes, so we can move forward to the next slide. So I think we have to proactively prevent sexual harassment, especially post the TCS case. I think, of course, the mandate has been there since 2013, but every time a sensational case happens, I think it just pushes us to ensure that there is a complete checklist, uh, and not only by compliance, but actually you prevent. So every organization, I think it's not only about ticking, giving a tick mark in a compliance checklist, but for this compliance checklist, you have to go a little beyond the mandate. You have to actually ensure that there is a cultural shift. There is a shift where every person treats each other respectfully, and therefore it is important to have these policies. It is important to have these redressal mechanisms in place, and it is important to have audits, regular audits, because now, of course, there is compliance also, which you have to, every government is ensuring that they send inspection officers as to ensure that you have these compliance in place, and especially also with the she-box portal, which you have to uh, register your company in with the she-box portal. So that is another mandate. The third mandate is, which is also important, is according to the Companies Act, you also have to disclose about your compliance with uh, you have to also disclose about the annual report which the IC has submitted in your annual report of the company as well, which is according to the Companies Act. So all these aspects is mandatory in nature. But like I said, you have to go a little beyond the mandates where you have, which is again a mandate of having uh, awareness programs. But whether or not these sensitization programs are uh, continuously taken for team leaders, for all employees, that needs to be seen. Whether or not there is a display, again, this is also a mandate, but make sure that the names of the members are displayed at every workplace, and there is a clear directive which is given that these all will be penalized. Any of these instances will be penalized. Also, having a secure reporting pathway, because see, any person coming forward and talking about sexual harassment, firstly, it requires a lot of courage to come forward and talk about it. So, ensuring that there is confidentiality, there are measures which are taken that the identity or the details of the person will not be disclosed, because if and of course there will not be any retaliation against these people who come forward to give complaints. That is also something which is very, very important. So like I said, these are certain mandates which are important, but you have to go a little beyond just the tick in the box compliance list, and making sure that you actually uh, have these mandates in place. And then thus, of course, not only having awareness programs for employees, but also having awareness programs for your IC members is something which is important. So when you go to the next slide, you will see that there is a entire duty for the employer which is being given under the law itself, under section 19. Also under the shebox portal, there are several mandates which are given, which the company has to upload on the portal as well. So these are some things which the company has to do, and if they do not do that, there is a penal provision which is there. One is, of course, there is a fine which can be attracted, which is 50,000, and if it continues, there can also be a cancellation of their license if non-compliance continues. So the companies need to take this very, very seriously. Second is also, many a times what may happen, that a aggrieved person may directly go to the police station to file a complaint, and if you do not take cognizance in time, and there are so many things which are attracting as a company, because it is an offense also if you do not ensure that you know the your duty is not looked into. So it is important that employers have this checklist. It's already given on the slide before you, but I think it's very important to ensure that they not only do a tick mark of the checklist, but they go a little beyond to ensure that people are aware of this, not only on the company intranet, but communication platforms, HR portals, and also giving assistance to the aggrieved women is also very important, especially if they want to go ahead to the police station and file a complaint. One needs to understand that the internal committee has powers of a civil court. So clearly, all the actions which will be taken will be civil in nature. Whereas the complaint which will be filed according to the criminal laws, which is the BNS Act, Bharatiya Nyaya Sanhita, that will be a criminal procedure. While these two are different, they will run parallelly. So, and a woman is free to go to any of these forums to file a complaint, maybe either one or maybe to both. But even if the company finds out that she's gone only to the police, still it is mandatory on them to go ahead and address her situation as well. So I think we can, once we understand that this is something which we have to do, we can move forward to understand if any complaint does come before the internal committee, which is the only forum which can address these situations. What exactly they're supposed to do is something which we also, as as for this audience, it becomes important to understand how the committee functions and what exactly they're supposed to do. Yeah. So if we can move on to the next slide, I think that's something which we need to understand how it moves through the system. But one, even before when we go and hand over this to Sir, I think I would like to just say that these compliance is are very, very important. Even the internal committees which are constituted, they have to file an annual report every calendar year, which they have to not only upload on the Shebox portal but also hand it over to the district officer, which have been constituted by the government, and also they have to give it to their employer or the board of directors, who will in turn put it in their annual report. So I think these are the important factors which we must look into. But I think moving forward, we need to understand how POSH complaints move through the system, for which I think we are waiting to hear so on this important factor as well.
Thank you. The aggrieved woman can approach any member of the IC, need not necessarily be the chairman of the IC, with a written complaint. And the complaint needs to be filed within 3 months of the occurrence of the incident. Now, there are series of incidents. Let us say in the year, in January, one incident takes place and she keeps quiet. April, another incident takes place, she keeps quiet. July, then October one incident takes place, and now she comes. Then from October, the October incident, 3 months from that, by that incident, she must file a complaint. Now, within 3 months, if she is unable to file a complaint, she must state reasons as to why there is a delay in filing the complaint within 30 months. If the IC is convinced that there is a genuine delay, they can condone the delay and accept the complaint even if it is beyond 30 days. So another 30 days, another 3 months is available for the agreed over. Once the complaint is received by any member, the member should forward it directly to the chairman. Chairman should convene a meeting of IC within 3 days. The meeting, the contents of the complaint must be discussed. If they find that the complaint has some inadequacies, they are at liberty to call the agreed workman and make inquiries. And if there are no what you call witness list, any documents have not been enclosed, etc., they can inquire with her. And if there are documents, the documents can be enclosed and the complaint can be resubmitted. This is one thing. Once the complaint is in order, and if she expresses inability to write the complaint on account of her illiteracy or semi-literacy, the law says that the chairman or the member should help her to draft the complaint. Now the complaint has to be written as she says. You should not add anything else. It should be written in the language understood by her, and after drafting the complaint, it should be read over to her. And if she is okay, then a line should be drawn. The complaint is because of her inability, it is written by the member of the IC, and it has been read over to her. She has approved it, and then her signature has to be obtained, and then the complaint has to be received. Upon the receipt of the complaint, within 7 working days, it has to be forwarded to the respondent, that is the person against whom an allegation of sexual harassment has been made. That person is given 10 days time to submit his say in the matter, his reply in the matter. In the first instance, the complaint has to be filed in 7 sets. 7 sets, the complainant should file a complaint. And then after receipt of the reply from uh, the respondent, and he denies everything, then there is a stage called as conciliation. The complainant should be told that there is a stage called conciliation by the IC. If she agrees, she must agree. Yes, I am ready. What is the conciliation? The IC must explain to her. Conciliation is to sort out the matter across the table and settle the matter. And it should be made clear to the aggrieved that no monetary settlement can be made here. If she says, give me 10,000 rupees, I'll close the matter, that is not allowed. All these things have to be told to her. And she must give the consent to embark upon conciliation proceedings in writing. After she says, I don't want conciliation, then conciliation stage is over. If she says conciliation, then it has to be told to him that conciliation, she is ready. Are you ready? He said, no, I don't want to get into conciliation. Finished. Conciliation is over. If he also agrees, and then he said, okay, I also want to close it. And what she wants? She says, I want a simple written apology from him that whatever has happened, I apologize for that, and then I will not repeat it in future. If that is acceptable to him, a written apology can be taken from him, and the proceedings have to be drawn, and an agreement has to be drawn containing the conditions under which the settlement has been drawn. And it should be mentioned that under no circumstances the respondent shall violate the conditions, that he will not stalk her, again, he will not harass her, etc. And later, if it is complained by the aggrieved woman that he has violated the conditions, etc., straight away the IC can advise the aggrieved woman to file a police complaint against him. Such a harsh provision has been made. Okay, now conciliation doesn't take place. Then next what? Next is the regular inquiry. Now, what does the law say? Law says principles of natural justice has to be followed by the IC. What is principle of natural justice? Everyone know. Everybody should be given opportunity. Nothing can be, no action can be taken behind the back of opponent, etc. But procedure per se, how the complaint has to be inquired into, has not been explained either in the act or in the law. Now, when I searched some judicial pronouncements, I stumbled upon one judgment, Ashok Kumar Singh versus Delhi University, reported in Labor Law Reporter LLR 2017, page number 1074. It's a Delhi University, Delhi High Court judgment, wherein the reference of the earlier judgment of the Supreme Court, Vidyut Chakrabarti versus Delhi University, where specifically what is meant by this principle of natural justice was discussed. And what the court came to the opinion that unless you allow the opponent to cross-examine the witnesses or cross-examine the complainant, it does not amount to compliance of principle of natural justice. So based on all these things, specific procedure has been laid down in this Ashok Kumar Singh versus Delhi University case. What is that procedure? The first and foremost cardinal principle that has been laid down is that the aggrieved person and the respondent shall never be brought together face to face. Never. They should never be made to sit face to face. This is number one. Number two, the aggrieved woman should be asked, apart from the complaint, based on the complaint, you want to give any statement that is called as an affidavit in the civil court. No, here need not be affidavit. A statement containing all the averments, etc., is obtained from her. Copy of the statement is handed over to the respondent, asking him to prepare a questionnaire which he would like to ask her. So a question is prepared by him, handed over that questionnaire to the IC. IC will scrutinize the questionnaire to find out any derogatory questions are asked, any questions which are embarrassing are asked, any questions which what you call that doubt about her morality, about her character, etc. Such questions the IC can delete. Such questions IC can delete, make a record in the proceeding that there are 25 questions list is given, 5 questions we found not acceptable, and we are deleting these 5 questions only. They must give reasons for that. Then the remaining 20 questions, she must call the IC should call the aggrieved woman, put the questions themselves. At that point of time, the respondent shall not be present. He is not to be involved. It is the IC which will ask the question. Then the question answers are recorded. They are read over to her. Her signature is obtained. Copies are made. Copy is given to her. A copy is sent to the respondent. Same procedure has to be followed with respect to the other witnesses of the aggrieved woman. Same procedure. Once that is over, the side of the aggrieved woman is over, then the respondent again has to be asked, okay, you give your statement in writing. Copy of the statement is given to the aggrieved woman, asking her to prepare questionnaires. The question is obtained. Again, it should filtered, checked, any derogatory, etc. The questions are removed. Record is made. Why they have been removed, the reasons have to be shown. Then respondent is called and these questions are put to him. His answers are recorded by the IC, then read over to the respondent. Then copies are made, copies given to him, copies sent to the aggrieved woman. Same procedure again with regard to the other witnesses of the respondent. Once this evidence, this is how the evidence has to be recorded. This is there in the High Court judgment, clearly spelled out. Otherwise, what I have seen is that now these ICs evolve their own what you call methodology of conducting inquiries, making them to sit against each other. Impossible. He will be his very stare will scare that lady, aggrieved woman. Stare. She won't be able to talk anything in his presence. I tell you. That's where the court said no question of face to face. Then after this is over, an opportunity is given to both the parties to submit any say in the matter. That is called the argument. Then individually they are called. the agreed woman is asked whether you would like to say something orally, we will record, or you want to submit in a, what you call that, in writing, you can submit that. Once that is over, same is the case with the respondent. So after that, it is said that the inquiry is complete. This whole process of inquiry has to be completed within a span of 90 days. After that, 10 days are available for the IC to prepare the report. Now, report must be the writing, it is like a judgment to come to the conclusion that whether sexual harassment has actually happened or not. A speaking order has to be written by the IC. The statement, the evidence, cross-examination of the complainant, respondent, and the witnesses have to be compared and then connected, etc., weighed. Then they must come to a conclusion. Okay, based on this statement, based on this document, etc., we come to a firm conclusion that sexual harassment has happened or sexual harassment has not happened. A firm speaking order must be written by the IC. Next, recommendation. What is the recommendation? If there are service rules existing in the organization or certified standing orders are existing in the organization, the IC cannot recommend any type of punishment. They have to one-liner. The sexual harassment charge has been proved. The employer is requested, recommended to take appropriate action as per the service rules or the standing orders against the respondent. This is one thing. Suppose if there are no service rules, no standing orders, in that case, the law has given power to IC to recommend the type of punishment. This is what. So during this process of inquiry, there are certain rights given to the agreed woman. The first right is that she can seek her transfer to another place, or she can seek transfer of the opposite party to another place. Then this recommendation forwarded by IC to the employer must implement it. He cannot dilly-dally it. Number two, the agreed woman says, I'm mentally distressed, I need rest, I need leave. So the law provides, apart from her statutory leave, 3 months additional paid leave is to be granted to her. So depending upon the requirement, the IC can recommend to the employer, you please grant her 2 months paid leave. The employer has to oblige, has to comply with this order. This is the during the interim period, during the period of the inquiry, this has to be done. After the report is received by the employer has got 60 days time to take action. Why 60 days time? Because under the standing orders or under 2 show cause notices have to be issued. So 15 days duration, 30 days are lost. And after receipt of the reply, then the third notice, which is inflicting punishment order has to be issued. So that is why 60 days time has been granted under the law for him. Then if the, one more thing I forgot to tell is that at the time of submission of this report by the IC to the employer, simultaneously, the copies of the reports have to be shared with the agreed woman as well as the respondent. It is incumbent, it is a must. Both have to be given copies. Based on the copy of that report, the aggrieved respondent can file an appeal. For appeal, 90 days time is required. In Karnataka, the appellate authority is the additional labor commissioner. Elsewhere, it is the labor court. The appellate authority will issue notice and then it will decide appropriately. The act has not stated anything about what order the appellate authority has to pass, in the sense whether the order passed by the recommendation is to be confirmed, it should be rescinded, it should be altered. Else, in any other enactments, the appellate authority is given specific power. These are spelled out. Unfortunately, this act has not spelled out what kind of judgment the appellate authority should give. So there ends the matter attitude. This is the entire procedure which has to be. And what is most noteworthy here is that every action is bound by timelines. Why? the lawmakers have understood this is a very sensitive matter of sexual harassment, and it cannot go on, it cannot be kept lingering months together, years together. No. Time bound within 90 days, inquiry must be completed. Within 60 days, punishment has to be filed. This whole structure of conducting inquiry and the timeline. Thank you.
So one quick question here. If the aggrieved woman is not satisfied with the outcome, what are the recourse available to her?
You mean to say if the recommendation is made that sexual harassment has not taken place?
Whatever.
Obviously, she's aggrieved. That's the only way she has to be aggrieved at. She has a right to appeal.
Okay.
She has a right to appeal. She can appeal.
So I'm giving two scenarios. One, as you mentioned. So if you have any questions, you can write on the Q&A. We will pick it up from here. Two scenarios. One, she's not. It has been accepted that something inappropriate happened, but the intent or the intensity was not identified, and the kind of punishment given was not up to the mark. Okay, or the kind of action taken was not as per her. She was not happy. She was not satisfied. Second, it was maybe it was decided that sexual harassment never took place. In both the scenarios, what are the recourse available to her?
The first one, Mr. Kohli, you said that the punishment awarded to the respondent by the employer, according to aggrieved woman, she is inadequate. Is that what exactly you said? What recourses are available to her, etc.?
Yes.
The law is silent on this.
Okay.
The law is silent on this. However, the standing orders, they say, the punishment that is awarded, there is again that appeal can be filed against that punishment before the appellate authority stipulated under the standing orders. So there is a possibility that the aggrieved woman can file an appeal against the order of punishment passed by the employer to the appellate authority specified in the standing orders. Then the appellate authority can look into it and you can vary the punishment, you can confirm the punishment, or you can dismiss the whatever it is. He has got power. That one route is available to her, but it is not specifically laid down in the law. This is the first answer. Second one, you were saying, what was it? I don't recall. Second
scenario is the outcome of the internal inquiry that there was no sexual harassment. Where is
then against that she can go to appeal. She can file an appeal.
She
can file an appeal. Definitely then to appellate authority that the conclusion reached by the IC is incorrect. They have not appreciated the evidence led. She can go for an appeal.
Okay. So, sir, before we go to the next, start talking, and Divya, this question, maybe I would request if you can also pitch in here. See, what practically we see, there are, if I talk about organizations in a pyramid structure, okay, the maximum workforce, is on the bottom level. And today, when you are looking at the factories, also, gone are the days when we said the women representation in the factories were lesser. These are the places where these are levels. I would say the maximum harassments happen, which never comes out, because maybe somebody at that level doesn't have is in a constant fear of losing a job. Somebody who's earning a 20,000, 30,000 rupees a month has a more job insecurity, because they know that possibly there are lesser opportunities available, and out of that fear, continuously they accept the harassment as a way of life. What practical scenarios or what practical advices you have seen given to your clients to address those scenarios, and how have what kind of outcomes has it led to? So,
Mr. Kohli, you have kept the finger on the pulse. You kept the finger on the pulse. In the beginning itself, I made a remark that the hesitancy is there amongst the women workers. Hesitancy. hesitancy. That hesitancy makes women not to come forward. Number one. Number two, there is a fear of retaliation. Number three is that looked up down by the colleagues, by the peers in the factory. Oh, look at that woman. That is the woman. That is the woman. They keep on beckoning. Kusu kusu. They will talk in a hushed manner, I tell you. Most important and very critical is the news goes to the family members that she has filed a complaint of sexual harassment. The son, the husband, and the mother-in-law, what they will do with her, you can imagine. Kal se don't go to work. There's a social stigma attached to this particular thing. That's why many women don't come forward to file complaints. Now, what I advise to my client is that massive awareness campaign must be unleashed at the organization level, reassuring the women that your name will be kept confident, secret, and no retaliation measures will be followed, etc. And nobody will know who is the accused woman, what has happened, etc. Nobody will know. That is why this face-to-face, they should not be brought in. That is the ruling of etc. And once it is done, the fear that is lingering in the minds of the women that if I come forward, I could be victimized. If the news reaches to my family members, I will be stopped from going to employment. This is there. This psyche is still there until that is why they mutely they endure sexual harassment. They don't want to come forward. Number two, now evidence to substantiate her say, the nobody is ready to come and depose in her favor. No documents. Then under the circumstances, the IC has to adopt one principle of preponderance of probabilities. Now, she complains, I had gone to manager's chamber. After half an hour, I came out. Now, half an hour, what were they doing? Was it her rendezvous, interaction with the manager required half an hour? So she says during this period, he touched me, he did whatever was not required to burn, etc. Should it be believed or not? So preponderance of probabilities. The IC has to look into this aspect. There was no need for the woman to be in the manager's cabin for half an hour. Her job was just 5 minutes. So like that, circumstantial evidence has to be looked into and a finding can be given, etc. There are lot of odds are there for a woman to establish the case of sexual harassment, I tell you. So massive awareness campaign, orientation campaign, and instill the confidence that nothing will happen to you. Nothing will happen to you. Come forward. Your name will be kept secret. Only that assurance, if it is given, or if there is a union can take. Otherwise, situation, they will not come forward. Out of 10, hardly one may come forward. My practical experience, I'm telling.
Yes, even I have had the same experience. So I think what is important to note is keeping the process extremely confidential and giving that confidence to the woman that there will be no retaliation. I think the role of the IC is very, very important here in order to address these kind of situations. In a confidential manner, in a manner which is fair, unjust, unbiased. I think the IC plays a very important role here.
There's a follow-up question on this. What if the presiding officer does not keep confidentiality and, what action should be taken or what is the prescribed action?
Mr.
No,
Kohli, there is a breach. Sorry, Diva, you want to say something? Or
no, sir,
you want to? If there is a breach of confidentiality, it is an offense under the POSH Act. The employer can take action against whoever has breached that confidentiality. Severe punishment can be given under the standing orders or service rules. Whoever it is, president or chairman or any member, etc. If there is a breach of confidentiality, if they come to know, etc., that person shall not be spared by the employer. Deterrent punishment is there. Deterrent. And I found in several cases, the IC goes to the spot where the incident has taken place, start collecting the evidence. They should not. The inquiry must be conducted within the four corners of the room itself. They cannot go to the spot, ask the colleagues, etc. No, that is not allowed. That's happening because of the lack of understanding of the procedure to be followed while conducting the case of IC. This Ashok Kumar Singh is the only case I'm telling you which lays down how the inquiry must be conducted.
Sir, Divan, one question to you. And we spoke about the age and the gaps today. One is a scenario of a factory kind of environment. What is the scenario today of a service-oriented organization, be it IT, ITS, and I would say ITES, and we saw recently the case of a TCS also, and that ITES has come again in the under a lot of scrutiny. How do you advise clients to uh, create awareness in an organization where the maximum population is between the age of 23 and maybe a 35?
I think, the lines have become very blurred. The kind of interpersonal relationships which we are now seeing, uh, they are they are very different. So here we really need to understand whether it's a Gen Z or a millennial or a Gen Alpha now, soon. So we really need to understand what exactly is going on within these different generations, because there are so many different interpersonal relationships, and it's changing with time, and we also need to adapt and understand what these relationships are all about. But at the same time, while we understand what is really happening, we really need to also ensure that we have a clear understanding to each and every person that no is, of course, consent really matters. Consent is a consent, intent, and giving respect to each other. I think that forms the basic basis or bedrock of any interpersonal relationship which will be existing. And when there are, of course, generational gaps, and the kind of situations which are there, uh, especially these days, we see extramarital affairs which are going, we see situationships which are happening, and there are so many much more names which are given to relationships. But I think everything, one needs to understand that consent and giving each other respect, especially in a professional setup, is very important. Like I always say, you always wear the badge of your company, even if it is not your working hours, you're in your own leisure time, but still you are recognized by your company. You feel proud when you say that, oh, I'm working with XYZ company, an employer. So you're constantly wearing the badge of the company, and therefore it becomes important to uh, conduct yourself in a particular manner. Like they say, the way people perceive you and the way you behave with people, that is the way people will behave, reciprocate as well, many a times. So even if there is a situation which is uncomfortable, I think it is very important to say no at the right time, to speak up at the right time, because if a person allows right from the beginning certain incidents to happen, then they will certainly aggravate. But that if a person says no, or is communicates in a proper way that I'm uncomfortable, this is unwelcome, many times situations can stop there and there itself without it escalating. So I think giving that confidence also to employees is very, very important, on how and when to say no, and the other person also to respectfully accept it, that it is a no, and I need to give that person their space, and I need not go ahead with my behavior.
Kohli Saab, since you mentioned about IT and ITES, Karnataka, let me tell you that Karnataka All these IT companies have sought exemption from the government from the applicability of the Standing Orders Act to their organization. And the government was too eager to give exemptions, 3 years. Every time the exemption is given. That means the entire standing orders is not available, not applicable to the employees of the IT. You can imagine now. You can imagine. Service, they don't have service rules, no standing orders, free for all. This is reality, I'm telling you. Anyway.
Don't want to comment much on that.
I think we had already initially spoken about it, and we understood that POSH is a civil law. There are no criminal processes. You cannot really punish or send a person to uh, punish a person in as how the criminal law punishes a person. So it is very important to note that these are two different issues at hand, and we must understand that the while the a person can you file a complaint under the POSH Act, it is also uh, important to know that a person is free to go and file a complaint under Bharatiya Nyaya Sanhita or with the concerned police station uh, under the relevant sections as well, because sexual harassment is an offense under the law. Uh, uh, Stalking is an offense. Voyeurism is an offense. So those will be which these relevant provisions of BNS do attract uh, a, penalties as well, where there is a 3-year penalty for an offense, etc., especially of sexual harassment. But whereas the POSH Act is primarily a civil and a preventive legislation, which clearly focuses on prevention, prohibition, and redressal, and creating safe workplaces through internal committees, through employer responsibilities, etc. So therefore, it becomes very important to note that these two, uh, while it is different, while the processes are different, the punishments are different, but at the same time, a person is free to go and file complaints with the relevant authorities under both these laws. The BNS, which was earlier known as the Indian Penal Code, earlier only rape and outrage of modesty of a woman was there in the criminal laws. But by way of Criminal Amendment Act in 2013, sexual harassment, voyeurism, stalking, etc., all these sections were also added into the law. And into 2023, IPC was changed to BNS. Now it's known as the Bharatiya Nyaya Sanhita. What is important and what we must remember, that internal committee is not a criminal court. It just conducts an internal inquiry for redressal. But if but it is also the duty of the company, of the internal committee, to assist the aggrieved woman if she wants to go ahead and file a complaint with the police and initiate criminal proceedings. So they have to give that kind of support. Therefore, it is very important to assist the aggrieved woman as well if she chooses to file a criminal complaint. Therefore, if you see the workplace, the sexual harassment at workplace has has dual consequences. One is, of course, the organizational and disciplinary consequences under POSH, and the criminal liability under BNS. And therefore, this really sends a strong message that workplace dignity and safety is not an option, they are actual legal rights. And therefore, as for us audience, it is important for us to understand both frameworks, that prevention is always the first step, but accountability is equally important, and therefore redressal mechanism is equally important. um, if you see that there are fines if the company does not really pay heed or do their duties, and therefore like I said earlier also, it should not be just merely a checklist, but something which the company goes beyond their um, beyond their checklists to make sure that their workplace is uh, safe and secure for all, and especially for women.
Divaji, what happens at the police station if a woman goes with a complaint of sexual harassment? actually what happens? Do they register instantly FIR or
See,
conduct
practically, if you
again
see
investigation?
instantly nobody registers an FIR. Only if it is
Okay.
a case of if there is a case of rape, etc., then they do register the FIR, and they are supposed to register a zero FIR wherever the lady goes and files a complaint with any police station, and then they direct it to the police station which has jurisdiction. But unfortunately, in practice, if you see, immediately uh, complaints are not, FIRs are not registered. Therefore, it becomes very important for women to actually go and file a complaint. And therefore, it is important to also the company to step in to assist the complainant to go and file a complaint with the concerned police station as well. And
Later, can
sometimes
they
if
file?
FIR is not lodged and that lady really wants to pursue a complaint of sexual harassment, then even the courts, she can approach the courts where she can get directions from the courts as well for the FIR to be lodged.
So it is a rigmarole again. It's a rigmarole running from pillar to post. I was
Absolutely,
saying
and
that.
then a
Huh,
criminal case, just filing, getting the FIR lodged is not the solution. You have to wait till the entire trial goes on, and we really don't know how many years the trial will go on. It may take 5 years, 10 years, 15 years. We really don't know how long that will take. But
huh.
the process under the internal committee, they have to complete it within 90 days. Of course, sometimes there may be delay, but at least there is a shorter timeline where actually the committee, the company can play a very important role to address these situations.
And in the criminal case, the aggrieved woman is subject to the rigors of cross-examination.
Absolutely. And that, like I said, there is a different process altogether when we speak about the criminal processes. The FIR is lodged, then again she has to go and speak. She's called before the JMFC for her 164 statement, which is
Hmm.
again very important. Again, she may be questioned by the concerned police station several times. She will
Ah,
also have to go to take for a medical examination.
hmm.
Many are so ideally it's best to go for medical examination to a government hospital within 24 hours. After that also, once 164 statement is done, and there is an entire again process of, if there are serious and if the perpetrator or the accused is going in for a bail, etc., to oppose that bail also she has to remain present through our advocate also, because at least her presence needs to be there while opposing the bail and why it should be rejected. So and then this is just part A. Then the charges will be framed, then there will be evidence, then the trial will go on, and then there will be 313 statement of the accused, and then there will be a final argument. So there is of course a long lengthy process, and in between if anybody goes to the high court, that's a different matter altogether. So the criminal process is, unfortunately, it is extended. But one thing what we also must understand is, um, when we talk about sexual harassment, we also must understand POXO, because if it is a child who is involved, any person below the age of 18, if she is the aggrieved woman and she files a complaint, it is compulsory on any person who comes to know about this issue to go and file a complaint with the concerned police station. It is mandatory. Like how in, if it is a woman, it is on her if she wants to go and file a complaint. But if it is a child, if anybody comes to know about it, it's mandatory. Now, here right now we are talking about companies and we are talking about POSH. I'm getting the aspect of POXO here. Why? Because many a times there have been cases which we've dealt with where for employee engagement, there are many family get-togethers which also the company conducts. There are many activities which also some companies go beyond their mandates as well, where they're uh, where they're constantly engaging the families of employees as well. And at that time, if any child, if any girl under the age of 18, she faces any instance, POXO will attract, and therefore it is important and mandatory for the company to go and file a complaint even if the parents don't want to go and file a complaint, still it is upon them to go and at least give a complaint. Let the police and the parents do what they have to, but they have to perform their duty. Otherwise, the penalties are very, very strict. There can be arrest also. So
Devadi, you brought a very, very interesting point here, because this is one aspect which we typically never talk about in our POSH trainings, awareness sessions, because yes, we talk about POSH beyond office hours, beyond workplaces. The definition of workplace is getting extended everywhere you are you're officially, but this aspect, I think, yeah, quite interesting.
Absolutely.
So, I think we read, this today I never looked at my watch. When we were talking about this is a topic where uh, I believe that we all need to invest our time and effort to understand more. And I would say put this more into our reflexes than our knowledge base. um, uh, that any such incidences, wherever we are encountering, we should raise our voice. We should, direct the person to the right place. And at whatever position we are sitting in today, if we are, by God's grace, we are in position of influence. Our position of influence should be, in the right direction, in the direction where we could guide people to to do the right things. I just want to conclude on, with a couple of thoughts in my mind. And, there was a question also ranked in the chat box. See, with the TCS case coming up, I will never agree that TCS as an organization doesn't have a, POSH
Yeah.
policy, POSH committees, everything is in place. Yet, such a thing happened, and it kept happening for months, quarters, years, right? What do? You have been filing on the sheep portal. You are doing everything. Now, what do we do with more beyond what is stipulated in law? I think if you talk about, and if you run organizations as as a large scale, be it retail organizations, be it an organization or ITITS, which has multi organization these levels. Maybe sometimes what is written in the law, what is the standard practice, you have to go beyond it. You have to understand your organization, you have to understand your culture, you have to understand the kind of people you are employing with, you have to understand the kind of demographic you are, where you are coming from. You know, understand what where your office locations are. This happened in Nashik. This possibly could have never happened in Pune. I won't say could never have happened, but I'm saying is the probabilities of happening in Pune or Bangalore would have been slightly less than Nashik, because maybe for somebody a job opportunities in Nashik could be less different than the confidence in the person who is an aggrieved party. The confidence of raising a voice sometimes get lower in a place like where the job opportunities are lesser. We know our organization. I think we have to devise our own internal mechanisms. It could be, audits. When I go to a retail company organization and say, oh, I have my, so many warehouses and there theft is happening. What do? You deploy different things. Windows. Uh, you have third-party auditors. You have random checks. You do everything just to save a few hundred and thousand or lakhs rupees, right? This is important. You just can't say, oh, this is a standard practice and I'll follow this. You'll possibly have to sometimes think beyond the standard practice as to how do you check the pulse. Today we are doing 360-degree surveys. Today we are doing external surveys for our employee, uh, to check the pulse of the employees. I think, anonymous surveys, on audits, whatever, something it can be done. That's one. Second, if I talk about, we are talking about the organization. I think today in schools also, a 4-year-old, a three in school also is being taught about good touch and the bad touch. And one very important thing which is taught to them in the class, KGs and nurseries also, is shouting. Okay. you feel uncomfortable, raise your voice and shout. Okay, that's the first lesson given to when to a child when good touch and bad touch has been taught. I think that's a basic premise. I think shouting, raising voice, and giving people a comfort to raise voice. That's the only answer. Nothing else beyond it. Um, let's let let's teach people who are actually grieved. There are false cases. There are everything. This law has been used, misused, whatever it is. But I still believe there is a lot which needs to be done with this regulations, this law. And people who are really suffering, they need to be they need to know about this. If you can give people voice, I think that's half our job is done. Um, rest, once it comes out, today there are many mechanisms it can come out and it can create a lot of ripples everywhere, like what happened in TCS in Nashik case. It created. And I'm sure today I'm seeing organizations which are doing um, uh, secret audits. We're sending third parties to their remote workplaces to conduct audits to check it. Yes, one voice, one media trial, and lot would what possibly change. So yeah, but again, it's a topic which keep evolving with people new, because every time there are new scenarios. Every month there are new people joining in the organization. You can't just keep resting on it. GST filing can easily be done because I know my consultant who's going to file it every month. But POSH compliant, my people are going to change every day. I can never say I'm 100%. Everybody is fully aware of the laws. So I think it's a game. It's something which is ever changing. So let's keep learning with this. And if you are part of a committee, if you are in an influential position, ask for more resources and more budget from organization to create awareness, as Divya mentioned in the beginning, that displays at the right places, making it visible. Uh, Sometimes when I know there's so much of awareness, I myself, if I have any wrong intention, I would stop. When I know the cameras are there, I would drive in my speed limit. And no cameras are there, I don't jump a red light. When I know there's so much of awareness, there's so many brochures, pamphlets available, uh, it may deter somewhat to even go and do anything which is inappropriate. So coming to an end, Divya, Vasan sir, thank you so much. Just want to ask you if you have any closing thoughts which you have. Otherwise, I think we should conclude for the day.
My experience is that a lot of awareness campaign has to be unleashed by the employers. There's one company now I have come across. They have prepared a video, 15 minutes video, which it is compulsory for every employee once in 3 months. They must view it. Once in 3 months, they must view that video. And whether he has viewed or not, that is again found out. This is one novel way of creating awareness, I tell you. But what is important is the workforce, most vulnerable workforce. They should be sensitized in such a manner that fear psychosis must be taken out of their mind. It's a social stigma. If the family members come to know that she has filed a sexual harassment complaint, husband will, what will happen? The husband, what will happen? What will mother-in-law tell? Such kind of a social stigma also is there, I tell you. All these things, a massive campaign must be undertaken. No holders, you find what you call sarkari holdings, giving all other schemes holdings, but not about POSH Act. No holding is there outside POSH Act ke liye.
I was sorry, I was on mute. Thank you, sir. I know, this is the topic. Towards the end, you think when you start thinking from your heart, I think you feel like you really want to shout out and start bringing change every minute. But I think we can take the baby steps and start creating more awareness. Divya, any concluding thought from your side?
I think there are two people who are raising their hands. If we want to take questions, or we could just maybe take it later. We'll be happy to take it later as well. Otherwise, I'll just conclude with my thoughts.
Yeah, I think people were, there was some questions on the chat box also. One related to the filing itself. The annual reports cannot be not hard copies are not being accepted, and we are required to file on sheep portal. Sheep portal registrations that is not getting approved and no response from the sheep box. What to do?
No, I know that's everybody is facing that problem. With the Shebox portal. So I think just write an email and keep, because at least if any official comes to question with you, at least you have that communication that you have sent all your details and you're trying to upload, but nothing has been, there's no response. So at least keep your communication on with the official email addresses, and you file, even send it, even if they're not accepting, send it to the district women and child department. If it returns, that's a different thing. Tomorrow if any compliance inspection officer does come to do a check at your company, at least you have things which are already you've tried your level best.
Next question: if there is no monetary benefit, then what penalty or fines to be imposed on the defaulter? You know,
Now, IC can award a monetary benefit, monetary compensation, depending upon the what you call that mental instability, harassment, psychiatric treatment that the woman has taken. Based on that, they can calculate and award compensation to her to be
And
given from the.
can the fine or penalty be imposed on the on the defaulter?
No, penalty cannot be imposed. Punishment can be imposed. Penalty cannot be. Only this compensation has to be recovered.
Okay. And sir, what kind of a penalties organizations typically do? If you can, the way you can also add something.
It depends from case to case, it depends on how serious the uh, issue is. So here you have to follow the Wednesbury principle as well, that is, the judgment needs to be reasonable. So it really depends on the gravity of every issue. So it can be right from warning letter, written apology, suspension, and it can go up to termination, depending the seriousness of the case. Um, but I think it is very important for the IC also to develop a good understanding on what the situation is, to analyze what the situation is, and is accordingly take action. For example, there was a person who was going to commit suicide. Uh, he was driven towards it. Of course, uh, then you have to really understand what is the situation and accordingly take the punishment as well. Not be fearful, but at the same time, understand, be reasonable, and accordingly take the punishment.
Last question: is cross-examination of a complainant and witness mandatory?
Yes.
Yes.
Okay. Rashi, I'm not too sure if you're still here, but yes, I think this answers. Right. I think that's all for the day. Vasan sir, thank you so much. Divya, thank you so much. And to everyone, I still see there are 78 people there. Thank you so much. We have extended our time way beyond what was stipulated. I think it's almost 2 hours right now. You kept patient, kept listening, and very frankly, I did not realize that it's already almost 2 hours. I would have raised alarms. I started raising alarms in 1 hour 15 minutes, but today I also didn't realize. I think that's a sensitivity of this topic. I hope when we do next session, on this, because I think this is a topic which we have to keep talking about more and more. We talk more and more awareness we create. I think maybe a little bit of change we would be able to bring somewhere. So with more, I hope to have more sessions on this, Divya, Vasan sir, and again, once again, thank you so much.
Yes. Thank you so much.
Manoj, I
Thank
know
you.
you have a question. You have a question. I think we will take it with you separately, and if required, maybe I'll have Divya also written. I'll address that query. Thank you.
Thank you so much for inviting. And I was really happy to be a part of this session, and also with Basant sir, who has so much experience. It is truly an honor to be sharing this platform with him as well. So thank you, Jayant, and thank you, the entire team of Lawbit. We've been working on this for a long time, and I think it was a great session. Thank you.
I also
Thank
thank
you.
everybody. Thank you for giving this opportunity. Thank you.
Thank you, sir. Have a good day. Thank you, everyone.